Good morning, everyone. My name is Ariela Wagner. I am the founder of SunRay Construction Solutions, a national construction document service. And today we have the wonderful Marty Bernstein from Law Offices of Marty Bernstein. And a little brief bio on Mr. Bernstein. He is a construction lawyer with 45 years experience representing all segments of the construction industry: owners, general contractors, subcontractors, and suppliers. Marty is also an active construction arbitrator and mediator. Marty has taught construction law for CAM and other trade organizations for over 35 years. As a construction lawyer, Marty has been continually recognized by his peers as one of the best lawyers of America, according to the Michigan Super Lawyers and Top Business Lawyers in the Construction Law. So without further ado, I introduce Mr. Marty Bernstein.
Thank you, Ariela. Thank you for that kind introduction. So I want to say at the outset that I am proud to be a construction lawyer. And what that means is that over the past 40 plus years, I have represented owners, contractors, subcontractors, suppliers, small, medium, and large, handling a wide variety of construction-related problems, from construction contracts, construction defects, construction lawsuits, which leads us directly into what we're going to discuss this morning: a remedy to help you get paid. On private construction projects, contractors, subs, and suppliers are provided a powerful remedy to obtain payment for their work, and that remedy is called a construction lien against the owner's land. Only in the construction industry can an unpaid contractor, sub, supplier, or laborer record a lien against the owner's property that can be enforced by foreclosure or sale. That's right, foreclosure. Just like a bank forecloses on a mortgage, a unpaid contractor, sub, or supplier who perfects its lien can force the owner's land to be sold to pay for your work. A very powerful remedy. What I'm going to focus on this morning are three common mistakes that I see that can prevent a lien from becoming, that can invalidate or make a lien unenforceable. I'm going to tell you what these three mistakes are right off the bat. We're going to go back to each of them, and I'm going to show you how to prevent these mistakes from occurring, and how SunRay can help you prevent these mistakes from occurring. So the three common mistakes are: number one, failure to timely record a claim of lien within 90 days of your last work. Mistake number two, failure to timely serve a copy of the recorded lien on the owner's designee. And mistake number three, failure to timely file a lawsuit to enforce your lien within 1 year after the lien is recorded. So those are the three top mistakes that I see. I'm going to go through each of the mistakes, talk about each of them. But before we get to mistake number one, I want to talk about a couple of other things that are very, very important in establishing your lien. Number one, obtaining the notice of commencement before you start your work. Remember, the notice of commencement is a document prepared and recorded by the owner, telling everyone in the world it's recorded, that tells you who the owner is, the legal description, the name and address of the general contractor, and the name and address of the owner's designee. That's the person designated by the owner to receive all notices and claims of lien. This notice of commencement, again, prepared by the owner, and you can obtain a copy either informally or formally. This is one big service that SunRay can do for you, help you obtain the notice of commencement. And as you will see, once you have the notice of commencement in front of you, it will help you do a notice of furnishing. It will help you prepare a claim of lien. For example, when it comes to the claim of lien, you need a legal description. Where do you get the legal description? In the notice of commencement. So that's the first thing. Get the notice of commencement early. Second, subs and suppliers have 20 days from starting their work to provide the owner, the owner's designee, named in the notice of commencement, and the general contractor, named in the notice of commencement, a document called a notice of furnishing. It is a notice that simply says who you are, what you're doing, and who you're working for, so that the owner can learn about people that it does not have a contract with. Contractors, people hired directly by the owner, a general contractor, a construction manager, typically a residential builder, are contractors. They do not have to provide a notice of furnishing. They receive them. They don't provide them. Why don't they have to provide a notice of furnishing? Because it is obvious, it is assumed that the owner knows who the contractor is because he's hired them. So subs and suppliers have to provide this notice of furnishing. Again, another service that SunRay can help you do. Help you prepare the notice of furnishing, help you serve it. It has to be served by certified mail or personal delivery, and I recommend certified mail within 20 days after starting. Remember, you can give the notice of furnishing before you start working, and also remember that even if you're late past the 20 days, you should still give it, because failing to give a notice of furnishing or failing to timely give the notice of furnishing within the 20 days will not automatically or will not necessarily invalidate your lien rights. Do it anyways. One other very important point for those people that do public work, and what I'm saying when I use the term public work is that work where the owner of the project is a city, a township, a village, a county, the state of Michigan, or the U.S. government. There are no liens on public jobs. Liens apply only to private construction, whether it be residential, commercial, industrial, whether it be new renovations or service work. Liens only apply on private construction projects, and each state has their own lien law. And again, this is something where SunRay can help you. Depending upon which state you're in, SunRay can help you follow the lien process in that given state. I'm going to focus on Michigan today because that's the primary area where I do work. So let's begin now with mistake number one, which is failure to timely record a claim of lien within 90 days after your last work. Whether or not there's a notice of commencement, whether or not you've given a notice of furnishing, in order to have a valid, enforceable lien, you must, I'm going to emphasize that word must, record a claim of lien within 90 days after your last work. If you come to me or anyone else on the 91st day, you will have lost your lien rights. You have 90 calendar days to record a claim of lien in the county register of deeds where the project is. So let's go back over. 90 days means 90 calendar days, not 3 months or 90 business days. Next, 90 calendar days means 90 days from your last actual work on the project. Not 90 days from your last invoice or warranty work. Warranty work does not count. However, punch list work does count. So you can, in deciding when to start counting, let me suggest to you that you start counting 90 days from when you pull off the job before you send your final bill. Try to be conservative. When you substantially completed your work is when you should start counting 90 days, and try to have some proof of your last work in case there's a question. So as an example, if you're a supplier, you would have a delivery receipt. If you're a sub, you may have a time card. Now today with the telephone, you can take a picture of your last work. So that would be an excellent way. Now, you must record the claim of lien in the county register of deeds, not where your office is, but where the project is. If you're working on a project in Grand Rapids, which is Kent County, Michigan, but you're working in Ann Arbor, Washtenaw County, you don't record the lien in the Washtenaw County Register of Deeds. You must go to the Kent County Register of Deeds and record the lien. Again, this is something that SunRay has the ability to do. This is what part of the services that they offer, and I would suggest very strongly that you use a service like SunRay to help you do this. You do not record a claim of lien by mail. You must do this in person. Try not to wait until the last minute, because if there's a problem with the claim of lien, such as you have the wrong form, you don't have the right margins, you use red ink instead of black ink, the lien will come back and you will have no time to correct it. So my advice is, you will know after 30 days, after 60 days, for sure, if you're not getting paid, and you should then proceed to record the lien within the 90 calendar days. Okay, let's go to step number 2. Once the lien is recorded, the power of the lien comes when you serve the lien. A lot of people make the mistake to think that once you record the lien, that automatically the owner of the property will receive a copy of the lien. Wrong. No one will find out that the lien has been recorded until you tell them. And how you tell them, and here comes the mistake that I see made. A mistake that I see made is that subs and suppliers who record the lien don't bother to serve it. So the mistake is that, or they don't bother to serve it timely. So mistake number 2 is failure to serve a copy of the recorded lien within 15 days after the lien has been recorded. And how do you do that? You do that by either certified mail or by personal delivery. Now, I recommend that you do it by certified mail. Why? Because the lien law says that when you put it in the mail, it is effective upon mailing, not receipt. Not receipt. I also want to strongly suggest that you use a cover letter. To use a cover letter to go with a copy of the recorded claim of lien. Again, another service provided by SunRay. Also, it is a very good idea to send a copy of the recorded lien, not just to the owner's designee, but to the lender, if you know who the lender is, to the title company, if there's a title company involved in making disbursements, and to the general contractor. What if, for example, you send the copy of the recorded lien by certified mail, and it comes back? Now, if it comes back, my suggestion is, yes, the law says it's effective on mailing. If it comes back, I would take the extra steps to make sure that that claim of lien is delivered, either by faxing it if you know who you're going to, emailing it, or having it personally delivered. You want to be in a position to show the court that the owner actually received the claim of lien. Here's another very important point. When it comes to serving the claim of lien, today I would go the extra step of certified mail and also using a method like email or fax that shows proof of receipt. It's extra insurance to prove that the owner received a copy of the claim of lien. Now, even if there's no notice of commencement, I would serve the claim of lien on the owner, because you don't know who the owner designee is. Okay, so we've covered steps 1, mistake 1, making sure to record the claim of lien within 90 calendar days of your last work. Mistake 2, making sure that you serve a copy of the recorded claim of lien on the owner's designee within 15 days after the lien has been recorded. And now we come to step number 3. Many people think that the lien lives forever or that the lien can be renewed. Both are common mistakes and misconceptions. The lien does not live forever and the lien cannot be renewed. You have 1 year from the date the lien is recorded to file a lawsuit to enforce or foreclose on your lien. So if the lien is recorded today, May 4th, 2017, you have until May 4th, 2018 to file a suit to enforce or foreclose your lien. That lawsuit has to be filed in the county where the project is, and that lawsuit has to have attached to it 2 important things. 1, proof of service of the claim of lien, a form, again, that SunRay can help you fill out, and also a sworn statement must be attached to the lawsuit. If a lawsuit, then you can file suit at any time within the 1 year. You can file suit the next day or within 30 days or 6 months. You cannot go past 1 year. If you do, the lien dies. The lien dies. It expires. So make sure that you keep that 1 year calendar in front of you once the lien has been recorded. So those are the top 3 mistakes. Those are the 3, and those we've talked about how to avoid them, how to prevent them, how SunRay can help you prevent them, because she can help you go through, use the her service to help to obtain the notice of commencement, provide the notice of furnishing, record the claim of lien, serve the claim of lien. All of those things are very important. All those things SunRay can do. I'm now going to stop and take some questions.
And if you're nervous to ask any questions right now, as always, you are more than welcome to send an email to, of course, Marty. His email address is below at mbernstein@martybernsteinlaw.com. And as always, you could email me and I could forward on questions to Mr. Bernstein.
If someone has a question, they can email me or they can call me.
Wonderful. Well, Marty, you did a fabulous job, and I hope everyone has a sunny day.
Thank you. Thank you, Ariela.